Good morning to all of you. Welcome to Legal Matters by Saibab Sunkara. This video is for the jurisprudence students. Friends, as promised, today I have come to give you the answers for the question paper for the year 2015. So let us quickly get into our topic. So question number 15. Question paper 2015, and we are starting from question number 15. A pregnant woman was injured in a train accident, and she gave birth to a baby with, of course, it was a premature baby, but with some congenital deformities. Now, this boy who was born with the so-called congenital deformities, he wanted to file a suit after attaining majority against the railways. Because of the accident, his mother received certain injuries. Due to those injuries, he also received the so-called congenital defective. పుట్టుకతో వచ్చినటువంటి ఇబ్బందులు అన్నమాట. సో కొంతమంది కాళ్ళు వంకర, చేయి వంకర, మూతి వంకర రకరకాలు వస్తాయి. Why his impression? They are because of the train accident. He wanted to make the train people to be liable. He wanted to file a case against the railway people. It is nothing but the vicarious liability. Of course, here two important points are necessary for the discussion. Number one, whether minor can file a suit or not. So you may be knowing, Indian Majority Act, a person who has not attained the age of 18 years is called a minor. So in CPC, I will tell you, suits by minor. Suits by minor, that is a separate topic. And please remember, according to the CPC also, the minor cannot himself file a civil suit. This is the best. You may know, you are studying the Transfer of Property Act and other things. A minor cannot per se file a file a civil suit against others. But he can do it. Please remember, he can do it through his next friend or legal guardian. Same thing. Definitely he can file a case. But here the important point is, so as per Indian Majority Act, he becomes a major. He wanted to file a case after becoming major. Where is the problem? 100% he can file the case, or he can file the complaint, or he can file the civil suit against the railways. But whether it will stand in the court of law or not, this is the legal point. Second point which you have to discover. Please remember. So because every child is a citizen of this country, and he is also ruled by the local rules and regulations pertaining to cases. Please remember. So please, minors cannot file a case. So they can file or they can sue with the guardian or next friend. Right. So as far as this case is concerned, so the negative reply, the negative example is there. I will straight away go to the case law. That is Walker, WL here, Walker versus Great Northern Railways, 1913. It happened 1913, not now. So Walker versus Great Northern Railways, 1913. Please remember, in this case, a pregnant woman, of course, while crossing the unmanned level crossing gate, she was injured in the train accident. When the train was coming, suddenly she could not escape, and she was actually negligent. Whatever it is, she was injured in a due to a train accident, right? So the result, as a result of which a child was born to her, a premature baby, but with defects. Please remember, with born defects. That's why I called it as congenital defects, right? Please remember. Then man, after becoming a major, he filed a civil suit against the railways and claimed compensation on the tortious law. See, because of your negligence, because you did not take proper care for the maintenance of the level crossing gate, then you caused the accident, and due to which I was born. Since I was in the mother's womb, I could not file the suit now. Now since I became major, I want to file the case. But still, the negative reply has come. Please remember, the court held that the minor cannot maintain a remedy for the injury sustained when he was in the mother's womb, because mother herself was at fault. She was crossing the track. How can you, the engine driver, expect that she is crossing? That too, he will be driving the vehicle at a high speed. So it is the caveat emptor. It is the duty of the pedestrian or the walker. So she has to be more careful. That is one part. The negligence is thrown on her part, but here the negative reply has come to the court. You can cite this case law, it is sufficient. We'll switch on to question number 16. So a person by name S died in the police firing. Of course, his wife was called S. She filed a civil suit for compensation, petition for compensation. But the state claims of sovereign immunity. So since it was done in the discharge of duty by the police department, so they did not pay any compensation. Whether state is liable to pay compensation or not. So as a student, please remember, better you say that the state is liable to pay compensation because hardly a life was gone. But there are so many cases where the state rejected the claim and the courts also agreed because it was done in the discharge of official duty. If you go to the record of every case of a police encounter or police firing, so the record is built up in such a fashionable way, in such a neat way, that the police say, that the police claim that this man retaliated against them. Even in spite of the warnings of the police, he tried to overpower the police, he tried to attack the police, he tried to kill the police. So therefore, since there is no other go, in the execution of the right of private defense, they shot at him. This is the record, and you will be surprised. A case of 307 IPC will be registered against the person who died in the police encounter. This is a quite common thing. I don't know whether you understood or it not. మామూలుగా సహజంగా పోలీస్ రికార్డు ప్రకారం ఏముంటుందంటే పోలీస్ ఫైరింగ్ అనే కేసుల్లో పోలీసులు ఏదో కూంబింగ్ ఆపరేషన్ వెళ్ళినట్టు, అక్కడ ఆ చనిపోయిన వీళ్ళకి ఎదురు తిరిగినట్టు, ఓ మానవుడా నువ్వు మాకు ఎదురు తిరిగితే నిన్ను అరెస్ట్ చేస్తాను నువ్వు రా అంటే, వీరేంద్ర వచ్చేది అరెస్ట్ మిమ్మల్ని కాల్ చేస్తాను కత్తి తీసుకుని వీళ్ళ మీద పడినట్టు, అలాగే నువ్వు సరెండర్ అని చెప్పినా విన్నట్టు. సో వాడు మా మీదకి వస్తున్నారు, వాళ్ళంతా వచ్చి మమ్మల్ని చంపే ఉద్దేశంలో ఉన్నారని చెప్పి పోలీసులు అనుకుని ఫైర్ ఓపెన్ చేసి ఇది రికార్డ్ చేస్తారు సహజంగా. So basic record will be like this. Of course, facts may be different. Facts to some extent చాలా 80% ఇలాగ ఉంటాయి. కానీ కొన్ని సందర్భాల్లో సహజంగా కామన్ మ్యాన్ ఏమనుకుంటా అంటే పోలీస్ ఎన్కౌంటర్ ఫాల్స్ ఎన్కౌంటర్ ఎప్పుడో పట్టుకొచ్చి తర్వాత చంపాడు అంటారు. సరే దానికి మనం ఏం చేయలేము, కొన్ని ఫ్యాక్ట్ కొన్ని ఇదో ఉంటాయి. బట్ వాట్ ఎవర్ ఇట్ యాజ్ హియర్ ద పాయింట్ ఈస్, సో యూ మస్ట్ రిమెంబర్, యూ మస్ట్ రైట్ ఆల్సో, పోలీస్ ఆర్ దేర్ టు మెయింటైన్ లా అండ్ ఆర్డర్, టు మెయింటైన్ పబ్లిక్ ఆర్డర్, టు ప్రివెంట్ అండ్ డిటెక్ట్ క్రైమ్స్. Is it not? And to prevent and investigation of the offences. These are the main important duties of the police. Of course, during the maintenance of law and order or certain times use of firearms definitely can be lawful. Please remember, the police can use minimum force, the reasonable force actually, according to CRPC. They can use it as a force. Suppose if there is unlawful assembly, they have to use force and disperse them only, is it not? So for maintenance of law and order, they can resort to firing. This is the last resort, please remember. So please remember, when there is an imminent threat or injury to their life, therefore then only they will open fire because the situation is grave and it is posing threat to the life of the police. And please remember, Article 246, it says police is the state subject. So definitely police can open fire. But what happens? Since the person dies, since the valuable life, Article 21, life and liberty of a person are more important as per the Constitution. So definitely, if there is any laxity on the part of the police, if there is excess on the part of police, if the police exceeded their limits during this so-called encounter firing, definitely they are liable to pay fine or compensation to the victim. Now we'll go to the case laws. Number 1, PULC, People's Union for Civil Liberties, PUCL, I'm sorry. PUCL versus Union of India, 1997. So PULC cases are so many, 1997, please cite it. So please remember, the question before the Supreme Court was whether state can deprive a person of his life and liberty rather than in compliance with the rules specified by the statutes. So Article 21 they have discussed. So please remember, they said that they have to take all precautions before killing a person. If they observe all the formalities, yes, they need not pay any compensation because this man has exceeded his part, the civilian. So they need not pay any compensation. But in this connection, the Supreme Court directed that, basing on the request of the PULC, they stated that a case of murder has to be registered against the police officers first, and then only investigation. If investigation reveals that there is no intention on the part of on the part of the police, and that they killed him during the encounter and the part of as a discharge of duty, the case can be closed and they need not pay any compensation. Here, registering the murder case against the police is more important. And secondly, so normally Nilawathi Bharara, you should not forget, Orissa case, Nilawathi Bharara versus State of Orissa, 1993. So please remember, her husband was taken to the police station on the actually suspicion that he was aiding the Naxalites. So he was not traced. Then this woman moved from pillar to post. Ultimately, she touched the Honorable Supreme Court. Ultimately, thereafter only, the police disclosed that he died in police encounter. There, the compensation was awarded to Nilawathi Bharara. So there, the Supreme Court held that the state is vicariously liable for the death of the husband of Nilawathi Bharara. Then another case, A. Anasurya versus SHO, I think Koyur, Karimnagar district, I believe, in combined state, 2000. So please remember, actually, Anasuya's husband, Mr. Adisesha Reddy, A. Adisesha Reddy, and 3 others, they were killed in police encounter on 2/12/1999. So the police, as usual, they said they have done it in the discharge of their official duty. So therefore, Honorable High Court ordered the State Human Rights Commission to investigate. You may be knowing, or I already have completed the topic also. Yes, SHRC is competent to investigate the matters relating to the violation of the human rights. Of course, I do not know what happened as a result of the investigation by SHRC. Right. Next, another case is there, though. There is Gera Kishore versus State of AP. I think it happened in 2006. Gera Kishore was taken from his house at Madhipadu. His sister-in-law came weeping to Ungoltali police station that her brother-in-law has been kidnapped. Ultimately, next day the body was found, a dead body was found in Madhipadu. And police claimed that since he was already involved in the murder case and since he is making preparations to kill another person, so when he raised objection or when he did not surrender, police used fire. Of course, so here the contention of the police was a proof, and therefore no compensation was awarded to her. Now we'll move on to question number 17. Government says living in relationship is illegal. Yes, even as elders we also say living in relationship is illegal. So, but as the common person, that is N, challenges it is violating the personal liberty, is it not? Yes, if they are willing, yes, have woman and man, if they are willing, they can live in together. So many things are happening nowadays. Even for years together, they are staying, then only they are getting married or somebody, or married or somebody, or getting separated also, right? So when this challenge came, the state says it is immoral. So number of judgments are there. This is a new concept. Of course, you all know that there is no specific law for the live-in relationship. So the issue in this case is whether live-in relationship is illegal or not. Not illegal. No. So please remember, it is immoral. In the view of the society, it is immoral. But in the eyes of the law, it is not illegal. Immoral, but not illegal. Please remember. So ultimately, to decide, or the fate of the live-in relationship is in the hands of the judiciary. Please remember, Allahabad High Court held that live-in relationship cannot thrive, cannot be successful at the cost of the country's social fabric. Our country, we give much respect to the marriage. Marriage is a very good system. The husband does not know the wife and he sees her only in the marriage pandal for the first time, but they live together for 100 years, is it not? So it is the social fabric. So it should not be disturbed by the so-called live-in relationship. So please remember. So therefore, they imposed a fine of 5,000 on a woman living with her partner. So live-in relationship in India is arbitrary. It can be taken on any side. So please remember, law insists, so please remember about the status of such relationship. So definitely it will be allowed. They cannot say no. Article 19, you can do whatever you like. So since there is no legislation, there is no act, the court also cannot do anything. Sometimes they will be expressing their opinion. Please remember, if court held that it is immoral in the eyes of the society but not illegal in the eye of law. Right? Two cases I am going to discuss. One is Payal Sharma versus Nari Niketan. So Justice Markandeya Kajju, he said that, maybe in the year 2011, he said that the individuals cohabiting, they are not criminal offenders. It's not a criminal offense. So live-in relationship is neither a crime nor a sin. Allowed. Second case, Lata Singh versus State of UP and another. Apex Court, Supreme Court held that live-in relationship is permissible only unmarried major persons of heterogeneous sex. So please remember, unmarried major persons, heterogeneous, not homogeneous, and not males and males, male and female. So if they live together, live-in relationship is accepted. So please remember, a person who is living in relationship with another, if he is discarded, if she is discarded, she can approach the court under section 125 CRPC. So to conclude, I want to tell you is live-in relationship is immoral in the eye of society but not illegal in the eye of law. Right? So there is another question. Already getting time. Anyway, question number 18. PO. P was declared to have passed some examination, BA, university gave him degree also, he joined MA, final first year also passed, but later, before he is taking the final exams, the previous university said that he failed in 2 examinations. So the seat, the present MA seat will be cancelled. Is it correct or not? 100% not correct. So there is, please remember, I will give you the lawyer case. Suresh Babu versus University of Kerala. 2018, Suresh Babu versus University of Kerala. Here, Suresh Babu is a lawyer and he got the law patta also. He got himself enrolled with the Bar Council of Kerala. Since he got the degree from the University of Kerala in the year 2007. But later, please remember, later the university found that he failed in contract law. So, therefore, he was directed to reappear for the examination. Then he filed a writ petition before the Honorable High Court of Kerala. So, Kerala High Court said that the university committed a grave error in declaring P as positive. You see their mistake, they should have verified. So, it could not compel for re-examination. University directed to forward his MA examination. That's all. You have to result. Since you declared him as passed, now you cannot say that you can. But please remember, what is the defense of the other side? Please remember, there are so many rules and regulations. Whenever the university finds that you have committed some mischief, you have filed, yes, they can take action against you. That is the law. But whatever it is, in the circumstances, so even Kerala High Court stated that the university at fault. So similar case. Another case is there. Suresh versus Mahatma Gandhi University 2012. And also I told you, in the law of torts, I think you can see, Krishnan versus Kurukshetra University. So they held that first they passed him, later they said, no, you have failed in one topic, so you have to appear for the examination. So here also, Krishnan was studying LLB. Since he was short of attendance, but he did not inform the mail. He said that he has got full attendance. He was allowed for the examination. The examination the university authorities did not make any proper scrutiny. Then he attended the exams. Later, university noticed their mistake and withheld the result of the plaintiff. So, court said the plaintiff did not commit any fraud. Of course, by mistake he might have stated that he attended the classes. So he did not make any fraud. The university should have done proper scrutiny before the exams. The court orders that the defendant to declare the result to withhold is not correct. They have to declare his results. So with this, question number 2015 is completed. So I have actually gone in a fast pace because I didn't find time. Anyway, it's getting 20 minutes. So please hear the video once or twice, make notes of the case laws, and definitely you can write the examination citing the case laws. It's better. So wish you all the success because you are getting short. I think you are preparing for the exams. So if any one of you ask me to give some more question paper, tomorrow also I am free, tomorrow also I can give you. For this, thank you very much, I am stopping.